The Honourable Adam Searle.
Mr Deputy President, on or about 7 March this year, a major New South Wales state-owned energy corporation, Essential Energy, filed an application to the Fair Work Commission, the Commonwealth Industrial Tribunal, to cancel the enterprise agreement applying to the company and its workforce. The agreement had reached what is described as its nominal expiry date, 30 June last year. Under the Fair Work Act, agreements are made for a period of time. When that time elapses, the agreement continues unless one of the parties moves to cancel it. This step is taken very rarely, but taken it was here in New South Wales by a government-owned employer, no less. And not just any employer. Essential Energy is one of the largest employers in rural and regional New South Wales. It has a workforce of nearly 4,000 people. Those wages are vital not only to those individuals and their families, but to the economies of towns and villages and regions across the state serviced by Essential. This company has already cut 350 jobs through the offering of voluntary redundancies and has flagged that it wishes to cut a further 800 jobs by June 2018. I understand that since the nominal expiry of the enterprise agreement, Essential has been in discussion with its workforce and their representatives, the Electrical Trades Union, United Services Union and Professionals Australia, formerly known as APESMA. I do not believe those negotiations had run their course before Essential had took this drastic step. I affirm this view because Essential has informed its workforce that, despite taking this drastic step, it will continue to negotiate on a new enterprise agreement, it says. If the application to terminate the agreement is successful, the workforce would be covered by the Electrical Power Industry Award 2010 until or unless a new enterprise agreement is agreed upon. That award has terms and conditions that are significantly below those contained in the present agreement. Now that shouldn't be surprising because the federal industrial system is based on minimum awards, with people then bargaining for new agreements to improve upon those situations. But this outcome means hard-won conditions and pay bargained for and often paid for by the workforce through workplace changes over the years can simply be taken away if the agreement ends. I note that Essential has made an above-award offer guaranteeing existing weekly base rates of pay, redundancy arrangements above national employment standards and the continuation of sick leave arrangements to its workforce. To secure these, the workforce would have to agree to certain patterns of working hours, shift work and on-call arrangements which are presently in place at Essential. However, the situation will only last for 6 months from the termination of the agreement, if the Fair Work Commission agrees to it, or when a new enterprise agreement is reached, whichever is the sooner. One of the conditions that would be lost to workers immediately is the protection they currently have from forcible redundancy. Relieved of this, Essential Energy could proceed immediately to cut the 800 jobs it wants to get rid of without having to wait. This would have a significant social and economic impact across the regions of the state serviced by Essential. And where is the party that claims to be the voice of rural and regional New South Wales? The National Party. So far they've taken no action to protect the people who work for Essential from the looming loss of their livelihoods. And as they would well understand, new jobs are not that easy to come by in the country. They are simply nowhere to be seen on this issue. Job losses should be a last reluctant resort for an employer, particularly a government-owned one, not a first easy port of call, and particularly not when negotiations remain on foot. I note that on next Monday, 21 March, there will be the first directions hearing of the Essential Energy application to terminate the enterprise agreement before Vice President Adam Hatcher of the Fair Work Commission. That will be followed by a process of discussion, negotiation, and if that does not resolve the matter, there will have to be evidence and legal argument prepared by all parties, no doubt at great cost both in terms of time and money, to say nothing of the difficulties caused for the workforce by the continuing uncertainty this process will cause. While Essential Energy is taking a course of action that is open to it under the law, it will have devastating consequences for the individuals and families directly affected. In my view, I think this is a terrible thing for them to have done. I do not believe that a responsible employer concerned with the well-being of its workforce and their dependents, to say nothing of the wider economy and the regional areas affected, should have taken this course of action at this time. Actions like this should be contemplated, if ever, only once all avenues of discussion and negotiation have been exhausted. Otherwise, steps like this can be seen as the easy road to taking advantage in difficult industrial negotiations, and that is contrary to the public interest and is not consistent, in my view, with the objects of the Fair Work Act or its provisions that mandate good faith bargaining. I ask, how can there be good faith bargaining when the workforce not only risks having their pay and conditions only given by the grace and favour of the employer, with the risk that they'll be taken away at any moment or expire if a new agreement is not entered into? We ask that the management of Essential should reconsider its actions If they do not, we ask for the shareholding ministers, Treasurer Berejiklian and Finance Minister Perrottet, to take action to stop this highly damaging course of events and ensure that the parties return properly and in good faith to the bargaining table until all avenues of discussion have been exhausted.